There is a lot of confusion with reference to the rule of alternate remedy. But the bench of Dr. D.V.V.L.N. Chandrachud and M.R. Shah has summarized certain principles related to the maintainability of a writ petition before high courts, even when alternate remedy is available. Just before getting into that, let's look at an important judgment on the rule of alternate remedy. Whirlpool Corporation versus Register of Trademarks, Mumbai, 1998, 8 SCC 1. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by the courts not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for the enforcement of any fundamental rights, or where there has been a violation of the principle of natural justice, or where the order or proceedings are wholly without jurisdiction or the vice of an act when it is challenged. Let's look at one more judgment on the rule of alternate remedy. Harbans-Lal Sahniya versus Indian Oil Corporation Limited, 2003 2 SCC 107. In an appropriate case, in spite of availability of an alternative remedy, the High Court may still exercise its writ jurisdiction in at least 3 contingencies. They are: 1. Where the writ petition seeks enforcement of any of the fundamental rights, or where there is a failure of principle of natural justice, or where the orders or proceedings are wholly without jurisdiction or the vice of an act is challenged. So, under these 3 circumstances, again, the principle of alternative remedy or rule of alternative remedy may not restrict any person triggering the writ jurisdiction. Supreme Court, in an appeal against the Himachal Pradesh High Court judgment, which dismissed a petition after noticing that the appellant has an alternative remedy available, the bench of Dr. D.V.V.L.N. Chandrachud and M.R. Shah has summarized the principles related to the maintainability of a writ petition before high courts. The principles that are summarized by the court are: 1. The power under Article 226 of the Constitution to issue writs can be exercised not only for the enforcement of fundamental rights, but for any other purpose as well. 2. The High Court has the discretion not to entertain a writ petition. One of the restrictions placed on the power of the High Court is where an effective alternative remedy is available to the aggrieved person. 3. Exceptions to the rule of alternative remedy arise when a. The writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. B. There has been a violation of the principles of natural justice. C. The order or proceedings are wholly without jurisdiction. D. The vice of legislation is challenged. These are the exceptions to the rule of alternative remedy. Now coming to 4th point, an alternate remedy by itself does not divest the High Court of its powers under Article 226 of the Constitution. In an appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternate remedy is provided by law. Where a right is created by a statute which itself prescribes the remedy or procedure for enforcing the right of liability, report must be had to that particular statutory remedy before invoking the discretionary remedy under Article 226 of the Constitution. This rule of exhaustion of statutory remedies is a rule of policy, convenience and discretion. In cases where there are disputed questions of fact, the High Court may decide to decline jurisdiction in a writ petition. However, if the High Court is objectively of the view that the nature of the controversy requires the exercise of its writ jurisdiction, such a view would not readily be interfered with. Hope the information is useful. Thank you very much for your patient hearing.